Then Shadow IR Minister Tony Burke said, Labor will deliver secure jobs, better pay and fairer industrial relations system by protecting low-paid, vulnerable workers like those in the gig economy, cracking down on cowboy labour hire firms, ensuring workers who do the same job get the same pay, closing the gender pay gap and criminalising wage theft. So it's an ambitious target. He recently also stated there is a direct line between insecure work and low rates of pay, and we need to stop replacing permanent jobs with low-paid, insecure and casual jobs where workers have no power to argue for a pay rise. Among its policies to tackle insecure work, Labor said it will extend the Fair Work Commission's powers to include employee-like forms of work and legislate a fair objective test to determine when a worker can be classified as a casual. So, dealing firstly with casual employment, Labor will amend the Coalition's definition of casual employment in the Fair Work Act so that employment status will be determined by the employee's shift patterns. It wants to ensure that employees working regular shifts for a defined period are considered as part-time or full-time employees, not casuals. These proposed changes are aimed at increasing employees' bargaining power and is likely to contribute to lifting wages. The new test will not be based on an agreement between the parties as provided with the recent case of Workpac and Rosato in the High Court and in recent amendments to the Fair Work Act, but on the arrangement the parties have judged objectively. The concept is against the grain of recent High Court cases which have said the terms of agreement between the parties is the predominant element in deciding the true relationship between them. In August 21, the High Court overturned a decision of the Federal Court that found that employees engaged on a casual basis but who worked regular and predictable shifts over an extended period were not casual. The court expressly recognised that casual employment can be for long term with a casual employee working regularly and systematically. The High Court rejected prior Federal Court authority where the contract is wholly in writing, the entirety of the relationship could be considered in characterising the nature of it. It said it's impermissible to look to the real substance and practicality of the relationship. The true nature of the relationship is found in the contract. So in other words, the message from all that is to get the contract right, to make sure the relationship between the parties is clearly stated at the outset. Labor is also going to introduce a limitation on fixed-term contracts. The intention is to stop consecutive fixed-term contracts, which provide limited security for employees, and to require that after 2 years on a fixed-term contract, or 2 consecutive contracts in the same role, the employee is to be offered a permanent job. Sham contracting will also be the subject of some Labor legislation. It intends to strengthen the anti-sham contracting laws to curtail the use of independent contract arrangements instead of employment agreements. It is worth bearing in mind that in this regard, sham contracting is not necessarily a deliberate thing. It can happen recklessly, and there are provisions to deal with where that occurs and penalties are imposed. We'll have more of that later. Measures will also be taken to extend the Fair Work Act protections to cover independent contractors. They will get the benefit of the NES, such as leave, maximum hours, flexible work arrangements, termination and public holidays, and the ability to request to convert their casual employment to full or part-time employment. On the assumption that some employers use labour hire workers as a strategy to bring in insecure workers at lower rates and undercut the wages of directly employed workers. Labor will make it unlawful to pay labour hire employees less than those who are employed directly with the employer of the same job, and presumably other conditions will not be any less either. A national labour hire licensing scheme will be introduced, but we already have one in Victoria, and that's been underway for a few years now. 26 weeks of paid superannuation 26 leave of superannuation paid for by the government and private enterprise is going to be introduced as well. That's not necessarily a federal thing, but certainly they're doing it at the state level, I see. In relation to the gig economy, Labor will introduce greater regulation of the gig economy. Ride share, food delivery drivers and the like will be provided minimum standards, and the Commission given powers to set minimum standards for gig and other employee-like workers. This is likely to include minimum pay rates, superannuation and dismissal rights of contractors who are not employees. The new log sought its own award, but was found to have been covered by the Road Transport and Distribution Award, an award which is wholly inappropriate to Menu Log or any of the other gig economy players, and that's currently under review, and Zoe will talk a little bit more about that. The existing 10 days unpaid domestic violence leave will become paid leave by legislation to be introduced. And Labor will consider introducing a portable leave entitlement scheme for Australians in insecure work. The scheme will allow workers from certain industries to transfer their leave entitlements when they move from one project to another or from one job to another in a single industry. The affected industries have not been named, but it seems those in insecure work will be targeted, such as food services, retail, arts and recreation, healthcare and social assistance. It's proposed to criminalise wage theft, but will not be able to do so where states already have such legislation in place, such as in Victoria and Queensland, where there is deemed not one conviction. Worth noting. The Minister, Tony Burke, said that during his time as a shadow minister, he made it clear that, Tony Burke made it clear that Labor wanted to get bargaining moving again. Not much was said before the election. The proposals are essentially to simplify the awards for small business employers and remove barriers to enterprise bargaining, end the ability of one party to end an enterprise agreement once the nominal expiry date has expired, give the Commission wider powers to arbitrate disputes in the context of bargaining, and improve access to collective bargaining, potentially through multi-employer bargaining. A trucking industry body will also be introduced to set minimum terms and conditions for truck owners and drivers. One of the other big things will relate to sex discrimination. The Sex Discrimination Act 1984 prohibits sexual harassment and sex-based discrimination. The new prohibition under Section 28AA of the Act against harassment on the ground of sex is intended to capture harassing conduct that is seriously demeaning or engaged in by reason of someone's sex, but not necessarily sexual. The Labor Party is committed to implementing the remainder of the Respect at Work report, which came out in April last year, with recommendations for preventing and addressing sexual harassment in Australian workplaces. The Sex Discrimination Act will be amended to limit the gender pay gap and require companies with more than 250 employees to report on their gender pay gap publicly, to introduce a positive duty on employers to take all reasonable and proportionate measures to eliminate sex-based discrimination, sexual harassment and victimisation, strengthen whistleblower laws, and prohibit secrecy laws which prevent employees discussing their pay, which is an interesting concept, and give the Commission the ability to award pay increases to those in low-paid, female-dominated industries. The reference to employers having to take reasonable and proportionate measures is likely to mean employers will have an obligation not only to provide policies but also training. Further changes are going to be made to sex discrimination laws, giving the Australian Human Rights Commission the function of assessing compliance with the positive duty, which will include power to undertake assessments of the extent to which an organisation has complied with the duty, issue compliance notices if it considers the organisation has failed to comply, enter into agreements and enforceable undertakings with the organisation if it hasn't, and apply to the court for an order requiring compliance with the duty. The Human Rights Commission Act will be amended to provide the Commission with a broad inquiry function to inquire into systemic unlawful discrimination, including systemic sexual harassment. It will also amend the Act to allow representative groups and unions to bring representative claims to court, and to review it will review the Fair Work system to ensure and clarify sexual harassment is expressly prohibited. Other recommendations include giving the Fair Work Commission power to grant injunctions, changing the Act to provide that sexual harassment is a valid reason for dismissal, and amending of serious misconduct in the regulations to include sexual harassment. While the courts have long recognised sexual harassment as a valid reason for termination, including termination without notice, this later change would make it clear that the employer should consider such an outcome within the ambit of the Act. Let's look at the last slide. So there's been a bit of development of the law in relation to the relationship between workers and the parties who engage in their services, whether they're employees or contractors. There have been many decisions and much controversy over the years. Two recent High Court cases changed this somewhat. Hollis and Barbaro traditionally used what they call the multifactorial test to determine the totality of the relationship, whether in that case couriers were employees or independent contractors. And in determining that issue, the court looked at such things as the parties' intentions, the degree of control over how the work was performed, the remuneration arrangements, the hours to be worked, the ability to delegate, who supplied the tools and equipment, and the financial responsibility and risk. Odco was another case in about 1989 that found that workers provided by labour hire firms to third party were independent contractors and not employees of either. But the High Court recently handed down decisions in which these relationships were examined in detail and upheld the primacy of the terms of the written contract in determining the relationship between the parties, changing the focus away from the multifactorial test when the parties have made a clear agreement between themselves as to what their relationship will be. There were two cases, the Forestry, Maritime, Mining and Energy Union against Personnel Contracting, also known as Construct, and ZG Operations and JAMSEC. Now in the Contract decision, Construct had a labour hire agreement with Hanson, a construction company by which it supplied Mr McCourt, a backpacker and unskilled labourer, to Hanson as a self-employed contractor. Construct was responsible for determining where, when and how Mr McCourt would provide labour, finding opportunities for him and paying him. In return, he had to tell Construct if he negotiated a pay rise and cooperate in all respects with Construct and the builder. An earlier High Court case of Odco found a similar but not identical arrangements made the worker an independent contractor. The High Court reviewed Construct's arrangements and determined that despite the attempt to portray him as an independent contractor, McCourt was an employee of Construct and not an independent contractor. There were two features in the contract leading the High Court to this decision. McCourt was not running an independent business. Construct could determine his hourly rate, pay his wage and terminate the agreement, and he had no discretion over what work he performed or how he performed it. Construct retained the right to control the work and how he was paid. The other decision was JAMSEC. You may have read about in the paper. Two truck drivers were initially engaged by a company, ZG Operations, as employees. In 1985, ZG notified the employees it was ending their relationship, but offered them an opportunity to buy their own trucks and become independent contractors. The drivers accepted the offer and both set up partnerships with their respective wives and subsequently signed contracts with ZG for the provision of the delivery services. They invoiced ZG for their services and paid the maintenance and operational costs of the trucks themselves. ZG had a high level of control, including the two had to be at the disposal of the business 9 hours a day, 5 days a week. After several years, the drivers commenced proceedings in the federal court alleging they were miscalculated or misclassified as independent contractors and seeking declarations for entitlements that they claimed were owed to them under the Fair Work Act, including superannuation, long service leave and other leave entitlements. The High Court unanimously held the two drivers were not employees. The court noted the contracts between the parties provided for the partnerships to utilise their own respective trucks and provide the services of the driver to drive them. Of significance was the context in which the contracts were agreed, namely that they were subsequently engaged as contractors after ZG ended the employment relationships and insisted the parties proceed only as independent contractors from there on in under a contract for the carriage of goods. Based on the terms of the contract alone, the court could not find an employment relationship. The court found, and it's important to note that from now, it is only where the terms of the contract are oral or ambiguous that the court can apply the multifactorial test against the practical reality of the relationship and the manner of performance of the contract. It is therefore important that employees give appropriate consideration of the relationship with their workers in their employment contracts accordingly. Just a couple of other things. Sham contracting. Sham contracting is illegal if the business knew or is reckless as to whether the worker was an employee. There may be a sham contracting arrangement, and there are penalties ranging from $13,320 for individuals and $66,600 for corporations for engaging in sham contracting. It's illegal to tell an employee they are an independent contractor, to say something false to convince an employee to do the same for the employer but as an independent contractor, to dismiss or threaten to dismiss an employee if they don't become an independent contractor, or dismiss an employee and hire them as an independent contractor to do the same work. And finally, all of this emphasises the importance of doing a few things at the end of the financial year. One is to review your policies and procedures and make sure that the policies and procedures clarify the obligations and rights of those who work for you, whether as employees or contractors. Ensure all employees have updated employment contracts, including to ensure they are paid the minimum rates. Ensure all other record keeping is up to date, including pay slips, time and leave records, individual flexibility arrangements and guarantees of annual earnings. And assess your casual workforce and determine whether any employees need to be given notice of their entitlement to seek casual conversion, which is what is happening more and more these days. So with that, I'll hand you over to Paul Barbaro. To Paul, yep, and he can tell you more about the employment marketplace and wages on the rise.
Good morning, everybody. Thank you, Stephen. Am I driving or are you driving this? I'm driving, aren't I? Yeah. That's a pity.
Can't only yellow.
It doesn't go anywhere. Right. Thank you for the introduction. I have to say, when I was asked to speak this morning, I reflected on 30 years in recruitment and realised that I'm spectacularly underqualified to speak about recruitment and employment, given that what we are currently seeing in the market is entirely unprecedented. But I did reflect on what had happened about 2 years ago on a flight that I was having in January of 2020. And I typically take about 60 flights a year, and if somebody had have said that would be The last flight I would take for 2 years, I'd probably argue that was not entirely happening. But on that flight, I'd asked my daughter, who was doing Year 12, if I could borrow one of her texts, and she said, well, this one here is pretty difficult. It's a completely fictitious work of literature, but it's called Station 11. It's about a global flu that sweeps the world, wipes out a significant portion of the population, causing clusters of people to live in isolation for extended periods of time and completely changing the way in which the human race works. So I did read it, I put it down and thought as if that had ever happened. And then I started flicking through the movies on my way to Melbourne and came across this movie that's called The Perfect Storm, and it's about a group of fishermen that were having a bit of a bad luck when they were trawling for marlin, and it's decided to extend their trip further north in search of really big catches, and they did get there and they did find it. But unfortunately there was a 1 in 100 year event where 3 completely independent storm cells migrated, forming one, and I won't tell you how the movie ended, but I remember thinking that's another piece of fiction, but in actual fact that was based on a true story. So 2 and a bit years ago, my perspective of the recruitment market is very different to what it is today. I'll speak to you not only from the perspective of recruitment and labour hire, which I've been working in for 28 years, but part of my portfolio is also overseeing the federal government's employment services contracts for both individuals who are unemployed but also individuals living with a disability. But I also oversee an RTR recruitment training company. So this presentation is less about just statistical information about what's happening in the recruitment market, but intuition that I suspect all of you are living in your respective workplaces. So I'll start by saying, if you're facing culture issues in whatever industry that you may work in, if you've got people complaining about their jobs, or if you are having salary pressures, i.e. people asking for more money, or if you've got, broadly speaking, disgruntled employees who are frustrated at what they have to do and where they have to do it, or if you have got or are experiencing higher turnover, then I just have to say you're pretty normal. Because we do an extended amount of work with industries right across Australia, not only in capital cities but in regional parts of Australia, and without exception, in over 3,500 industries that we speak with, all of them report those 4 things happening either independent of one another or in their entirety with workforces across Australia. So today's presentation really is looking at 4 things, not just salaries, because looking at just salaries without the context of what's happening in the employment market disregards why salaries are experiencing changes. So I'll look at the employment market from an unemployment perspective as well as an employment perspective. I'll look at the expectations and the trends that are emerging in the markets across all of the sectors that we're working with. Then I will look at salaries and what we are experiencing now and potentially what we might experience moving forward, before pausing for a little while and talking about what the future might look like based on what a number of futurists are actually suggesting it might look like based on all of those factors. So I'll start with there with the agenda item I spoke about. So I'll start with the employment market and what it looks like. And in the current employment market, what we currently have is just over 16.6 million employed people, which is a participation rate, being the amount of people in Australia of a working age of currently 66.7%. That is a very high participation rate by any measure. We've got a 3.9 unemployment rate, which is, as you will all know, a 50-year low. And I've called out youth unemployment for a reason, because youth unemployment typically has been substantially impacted, because at the height of COVID, most of the industries that typically employ younger people were shut down pretty quickly. But youth unemployment now is hovering at 8.8%, which is down from a high of 11.6 in 2020. Some of the interesting aspects of why I've called those out is because if you break down the different categories of unemployment in Australia, a really interesting trend starts to emerge. And the first of those trends are, if you're in the age group of between 15 and 24 years, typically, and you're unemployed, it will take you on average 31 weeks to find a job. If you're in the age bracket of 25 to 54, where the unemployment rate for that cohort hovers around 2.9%, it will take on average 58 weeks for an individual to find a role. But if you're in the 55-year-old and older age bracket and unemployed, typically it will take, on average, 84 weeks for a person to find a job. Now, the reason I've called those numbers out is recently we are having, for the first time ever in 30 years of recruitment, actually it's 28, it's not quite 30, I'm not that old, but the first time ever we are having federal and state departments asking us to engage with 55-year-old individuals and seek them out of either retirement, if they are qualified in a particular area, or to entice them back into some form of meaningful employment to cover what is now becoming a chronic shortage of skills in virtually every sector across Australia. So when you look at unemployment, some of the factors that have influenced unemployment is this, and that is the great migration away from capital cities into regional centres. Between March 2020 and October 2021, in capital cities we had real employment drop by 0.10%. But in the rest of Australia, regional parts of Australia, it went up by 1.3%. And you will all know intuitively that people have been moving away from capital cities for reasons that included, but weren't limited to, better freedoms in those areas, more availability of employment, and either tree or sea life changes that really have seduced a lot of people away from CBDs. We're seeing that trend reverse now. People are coming back. We're seeing in capital cities a 3% surge, and in regional parts of Australia slowing down in terms of employment. But perhaps for me, the most interesting statistic was this: for over a 20 or 30 year period, the fundamental shift in behaviour of individuals who are employed. And if you look at the green line, that's the number of permanent full-time roles, and you can see that they have over a period of time declined. So people are no longer wanting permanent full-time work, because the pink line is permanent part-time work. People are more engaged in wanting to work but not wanting a 9 to 5 Monday to Friday job. There's been a fundamental shift in Australians' attitude towards employment. So when you look at the total both employment and unemployment market, what I've just put here an industry of work there. I'll talk about the industries that are growing a little bit later on, but there's been a gravitational shift. In 1992, 8% of Australia's marketplace were manufacturing jobs. That is now only 1.5%. The shift has been more toward professional services and healthcare, as you would appreciate, given the ageing population. But broadly speaking, when you look at the employment market, there are 5 key things that have emerged that as employers we need to be aware of. And the first is that there are just fewer people. We have an ageing population. There is a chronic shortage of individuals for skilled roles, which is one of the reasons why we're seeing salaries increase in virtually every area in which organisations are recruiting. The second thing, and the most significant thing, is that expectations and attitudes of individuals have changed. I'm going to talk a little bit more about that in a few moments, but for those of you that are working in any industry, you will know that it is now a candidate or person-led environment, and where policies and frameworks need to be adapted according to what your staff are demanding, as opposed to what the fundamental premise of a business has traditionally been. Staff engagement is a really critical aspect of it, and I want to speak about ways to engage staff outside of just high remuneration models, because employer expectations and employee expectations seems to be moving apart as opposed to gaining more traction. And the reality is that employer pioneers, those organisations that are actually looking at engaging in really unique work environments, are those that will succeed over those that are taking on more traditional models. So if 40 years ago Elon Musk or someone similar said that I expect everybody to work in an office for 40 hours, most people think, so what? That's 40 hours, that's a pretty good job. In today's environment, people just take a great big gasp because they see that as being completely and utterly unrealistic in terms of the expectations that people have from their employers. So, speaking of expectations, what is really happening and what are some of the trends in the workplace, and how are these leading into salaries? Well, in a recent McKinsey & Company survey, we found 5 significant trends in the workplace. Firstly, 58% of surveyed employees said that they would ideally like to work from home 3 days a week. That would be their ideal. And 25% said if they weren't given that level of flexibility or something close to it, they would consider leaving their work. Perhaps the biggest emerging trend in the market has been that almost half are now saying and citing that mental health is the single biggest challenge facing employer groups. And the ability to provide mental health has been taken up by almost half of employees, which is at record high. One of the areas that I oversee in the organisation is an allied health team of 50 psychologists nationally that provide support to external organisations. We could have quadrupled that team and still not kept up with the demand that they have been placed under, such has been the strain that they have had to endure over the last 2 years. But the most significant thing really that has become prevalent and that I'm fiercely supportive of is individuals saying that they have become anxious at organisations not having a vision or a clear direction and a clear path. And I say that from the perspective that a lot of organisations who have actually had to change their work models from being traditional to hybrid have been challenged in terms of to what extent do we communicate to our cohorts and how do we communicate. And most employees that we have surveyed have said that they don't believe that the communication or the plan that has been put forward by their employees is sufficient for them to keep their interests. So I'll skim over some of the expectations, but there's a couple of things that need to happen for organisations before we talk about salaries. And 80% of employees said that the thing that they want is their organisation to reflect on what has happened over the last 2 years to determine whether some of the hybrid work models that have been introduced are able to be sustained and whether there are other remuneration models that could be adopted that will assist them to keep engaged, to recommit to wellbeing programs. And wellbeing in the eyes of employees is not just psychological wellbeing, but they talked about their financial wellbeing, to have some level of comfort that the organisation they're working for will remain solvent over the period of the next few years, to re-engage with a clear direction and of course flexibility that I'll talk about. And that's largely because 54% of employees across Australia are what we broadly refer to as blue skiers. They're in the office, they're working, they're engaged, they're committed, they're productive, but they're also thinking about other things. How long will it be before I can legitimately retire? How much money do I really need to live a lifestyle that's consistent with my new demands? You know, is this really what I want to do long term? Do I need to reskill to change how I do it? 30% of the workforce is what we would broadly say is actively disengaged, regardless of what you pay, regardless of what you do, regardless of the infrastructure and support that you provide. They are actively disengaged and they want out of the employment that they're in. And 16% are what we broadly refer to as people that have got presentism. They're there physically, but they're not really as productive as what they would otherwise be. And so this becomes a very critical piece for any decisions that organisations need to make insofar as longer term sustainability with their employees, because simply paying people more without having broader context for them won't keep them engaged. And so that brings me to the key point of salaries. And I'm not going to be saying anything to anybody in this room that you don't already know, and that is there is simply not one answer in regards to what people should be paid for any of the sectors in which you work. There are principles that guide salaries. We've seen the minimum wage increase for the lowest paid workers go up. But when you look at salaries, you also have to look at demand, and this is what's happened for the period to February 2022. 78% increase in demand for human resource managers across Australia. It is almost full employment for HR professionals. The environment that I work in, we have got 12, and I know that we have had a significant increase in salaries purely to retain those 12. In terms of growing that team, it is an exercise in incredible frustration to find people within a salary band that is considered normal. Aged care and disability care, as we all know, this has been an area that we have been brokered by the federal government to get 50-plus-year-old people out of retirement to get into a sector, and we are looking at paying them over and above minimum wage because we can't find enough. General managers, but interestingly, general managers with a clear focus on people management are up by 57%, and hospitality and retail services up by about 45%. You would expect that on the basis that they are coming off a very low base over the last 2 years. Broadly speaking, the salaries in Australia look like this. If you're in a $500,000 plus salary, you're representative of the highest 5% paid Australians. If you're on around the 290 plus, you're in the top 20%. And then we've got this big conglomeration which represents really 80 to 90% of the total market that is paid between 160 and it's down as to about 41. And that's where the talent fight has been the most fervent in all of those salary bands in all industries that are from here down to about $41,000. What we're seeing in salaries over the last 20 years is this. We've seen highs and peaks and troughs, the troughs during global financial crisis where you inevitably have salary changes, and now we're seeing pre-pandemic salaries creeping up, and that's in the private sector as salaries continues to spike. But there is no one formula that will be able to say, in the private world, how much would you pay a fee generating or an individual with skill sets that are specific to the sector. You need to make that determination based upon your own reflections of your organisation, other than to say that we're seeing spikes in salaries now to the extent that we haven't seen for a long time. The other thing that we're seeing in salaries is that these salary spikes are also coming with people working part-time. So they're still getting salary increases, but working 4 days for a salary that would typically have been paid for them having worked for 5. So it's going to be a very competitive market across all the sectors because, you know, the 68% of employees have actually said that in addition to salary, there are other non-revenue related incentives that would motivate them to stay. And if I were to tell you that the single biggest thing that surveyed Australian workers across 50 different industries right around Australia said that the thing that would engage them more than salary was attention, to get attention from their line manager, authentic attention about what they're doing, how well they're doing it, how they perform, whether they are appreciated. That was the biggest thing that they wanted. And the second thing was their job titles changed to sound more senior. So, you know, we've got a scenario where you do need to be competitive for the sector that you're working in. But I'm of the view, and I'll talk about this in just a few moments before I wrap up, is that I don't believe that the fervent excessive demand on salaries is sustainable for the long term. I think the markets will plateau, and I think that the expectations that people have of their incomes will also minimise as markets begin to stabilise. But at the moment we're working at an inflated rate and people are demanding incomes that frankly are not sustainable for corporate Australia. The second thing is to look at alternative incentives that are financial in nature, that might include healthcare benefits, might include financial planning to lock people into the organisations that they work so that they get better outcomes for the incomes that they're earning. A lot of non-financial incentives are currently being offered in terms of travel, now that you can travel, and the work from anywhere scenario. In 1992, 4% of Australians worked from home. 5% of Australians work from home, and 1% of them were farmers, so in theory you could argue they have to work from home. We're going to land on probably 20% of working Australians that will now demand to work from anywhere, not just from home, because the flexibility of the workforce is such that productivity hasn't diminished, people's ability to perform their tasks haven't diminished by being able to be flexible, and at the peril of an organisation if they don't offer that level of flexibility moving forward. So on that, what does the future look like? Oh, well, I'll put that up there because despite whatever you do, when you have a salary review, however much you pay people, if you survey that same group about 2 months, 3 months, 16 weeks after you've done that, 25% or so, I'm still not happy with my salary. even if they got an increase. So you're never going to make them happy because you're always going to have to be increasing incomes because it's only one dimension of a much broader conversation. If we look at what the future will look like, realistically, there's a number of things that will take place in Australia over the next little while. The first thing is... Sorry. The first thing is that the hybrid working model is here to stay. You've heard that a lot, and I'll reiterate it. I don't believe organisations will go back to being 9 to 5 office-based for all employees all of the time in the future. There will be an absolute requirement for every organisation in virtually every industry that you legitimately can to have a hybrid working model. It would be a really significant step for an organisation to remove that. And if any adopt that policy, I believe that their turnover will become so significant that they won't be able to sustain their income. That's the first thing. The second thing is that we're all talking about the talent shortages. Well, the talent shortage globally has been in play for a long time. In fact, 10 years ago, I presented with Bernard Salt, and I made a comment at that 10 year, and that was that by 2050 there will be more people of a retirement age in China than there are citizens in the US. That hasn't changed. We have got an ageing global population. The COVID-19 has only exacerbated the shortage of talent because borders were closed domestically, international borders were closed, working visas stopped, international students didn't come to Australia, and industries that relied on those very individuals to sustain themselves were in a position where they couldn't. And now we're fighting for a talent group of about 18.5 million Australians to support work that typically was performed by not only working Australians but also a number of international individuals. The third is wellbeing. And one of the most significant things that needs to happen, and that will continue to happen, is that new strategies need to be adopted by employers to make sure that the wellbeing of their staff is paramount to any policies that they adopt. High turnover will not change because the emotional cost to leave is a lot lower. When 50 years ago, work for life, people were engaged with their employer, they worked for a long time. There is a sense that people will have upwards of 15 different career changes in their working lives and will work for, in addition, in excess of 25 different employers. The emotional engagement that people have to an organisation is so low that leaving becomes so much easier. So high turnover will continue. And one of the things that really will potentially become a significant principle is that in addition to looking at competitive salary, organisation introducing formal shorter weeks. In the not-for-profit sector, many organisations have adopted a 4-day working week. Others have adopted a 3-day in the office working week, 2 days working from home, and some are even offering working on the weekend for some functions that can legitimately be done on the weekend and are not working during the week, and therefore reducing their expenditure. But look, to finish, this is a really obvious point, but the reality is the single biggest determinant of success for any organisation moving forward, of course, is people. And there is a clear delineation between organisations that have access to the same people, they have access to the same technology, they have access to the same economic environments in which we all operate. Some organisations prosper and others don't, and it's all based on their ability to not only find individuals, but to engage individuals, to motivate the individuals and to keep them. That in itself is a presentation that can go on for another 40 minutes, but the primary function and the primary motivator moving forward is an organisation's ability to find individuals, keep them, engage them and motivate them. But you can expect salary creep to continue, particularly over the next 6 months. I say this very cautiously in a room where there are some legal minds. I do believe, and history supports it, is that after the peak that we will see between now and March, we will see a stabilisation of salaries because the markets will dictate that some of these very inflated costs at the moment are not a sustained one. So thank you, everybody.
Good morning, everyone. everyone. My name is Zoe. I'm a lawyer at Aitken Partners. Today I'm going to cover 3 recent developments in employment law, which is in relation to the gig economy, the bullying policy, the intellectual property. Starting with the gig economy, Manual Law applied for a new employment award to be created specifically for food delivery workers trying to become the first gig economy company to make all its workers full employees. However, the Fair Work Commission said that the Road Transport Award currently covers employees of Manual Law in the on-demand delivery services industry. But if you look at the Road Transport Award, it does not have the flexibility required for Manual Law drivers. For example, the award requires a minimum of 4 hours shifts and does not allow split shifts. It sets out ordinary hours is from 5:30 a.m. to 6:30 p.m. But that's not necessarily when the Manual Law drivers would work. And there's also penalties for peak times, such as nights and weekends. This doesn't necessarily work with Manual Law either, because food delivery orders usually happen at night and on weekends. The next step in this matter is for the Fair Work Commission to consider whether the Road Transport Award for the purpose of covering Manual Law drivers would meet the modern award objectives in the Fair Work Act. And if the Commission considers the award cannot cover such workers, it may create an award for them, which would be in keeping with the federal government's intention to have an award to cover such workers. If a similar company such as Uber is found to be covered, it will be automatically covered. No agreement is required. If it's not found to be covered, it looks very likely that a new award will be created, as the Labor government has expressed their intention to for such covers to be covered by an award. Moving on to the bullying policy and the importance of employers having policies in place and following them. In a recent workplace health and safety prosecution, a fashion retail business was convicted and fined for offences solely related to bullying. So what happened was that the injured employee, while taking her time away due to a workplace injury, was alleged by her manager that she faked her injury to obtain workers' compensation. The employee was charged with the failure to provide and maintain a safe systems of work, and there are 2 bases that the prosecution relied upon to prove that. The first one is that the employer failed to regulate inappropriate bullying behaviour, and the second one was that there was no policy or procedure in place to address such behaviour. And as a result, the employer was ordered to pay $10,000 fine and more than $10,000 of the prosecution's costs. The amount would have been way higher if the employer did not plead guilty. What's important is that the company's lack of appropriate policies and procedures to prevent bullying and harassment was the key to the conviction. So this case also highlights the rising trend of safety regulators prosecuting employers for causing or posing a risk of psychological injury. So it's important for the employers to make sure that the proper policies and procedures in relation to bullying are in place to minimize the risks of being prosecuted. Now moving on to the importance of employers having appropriate employment terms and conditions to protect their intellectual property. There was a recent decision of the Fair Work Commission in relation to an employee's infringement of the company's intellectual property, and his dismissal was upheld. The employee was the head of design of a company that utilizes artificial intelligence to search and compare a large amount of patent records, allowing its clients to streamline research and provide efficiencies in innovation. The employee was responsible for developing the company's visual branding and software design, which means that he would have access to the company's trade secrets and confidential information that only the company's employees would have access to. A key fact in this case is that employee not only signed an employment agreement, he also signed a confidential and intellectual property assignment agreement, which require him to protect the company's intellectual property and not to disclose without proper consent. So during his employment, the employee publicly released a design system very similar to the one that he designed for the company. He also publicly released some features of another program that's still under development within the company. The company found out and did its investigation and terminated the employee without notice. And the employee then made an application to the Fair Work Commission claiming that the dismissal was unfair. The company relied on the Small Business Unfair Dismissal Code, which provides that a dismissal is compliant if the employer believes on reasonable grounds that the employee's conduct is sufficiently serious to justify immediate dismissal. And the Fair Work Commission found that the dismissal was compliant, and the reasons can be summarised in two aspects. First, it was found that the company carried out thorough investigation and obtained legal advice prior to the dismissal. So it was held that the company did have reasonable grounds to believe that the conduct was sufficiently serious to justify immediate dismissal. And also with respect to the employee's conduct, it was held that the conduct was willful and deliberate and inconsistent with the employment contract. So what an employer should know from this case is that having an adequately drafted employment agreement can also protect your intellectual property. And this is in addition to any common law intellectual property protection. And that's all from me today. Thank you very much. I'll hand you over to Stephen for any questions. Thanks.
Zoe, now, does anybody have any questions arising out of any of the cane?
Yes. Paul, please. Well, you implied that productivity was about the same, I think. My guess would be that productivity with this flexible hybrid model is decreasing, not increasing. I'm not saying the same.
Well, of course, it depends who you speak with.
The government.
Yeah.
That'd be terrible.
Yeah. Well, if you look at it, the professional and the service industry, productivity actually has not diminished. Most organisations that provide those services argue that their productivity has remained the same. There might be some industries where productivity has diminished. The argument from those industries is that it's not based on the flexible work arrangements, but logistics associated with those industries that has caused productivity losses as opposed to the engagement of people. Most people have argued that their ability to work in a flexible environment hasn't changed their output.
They might.
Well, while you're there, you put up a picture of a brain.
Yep.
And and it was a lovely brain. And the three areas which added up to 100% were people who were reasonably happy but thinking about where they want to be and what they want to get, people who were essentially disengaged and actively looking, and I think the other group, they were present but not really there, if you like. And this isn't a criticism, what I didn't see was anybody who's satisfied with their job, happy and content. Is that, am I just missing the definition of blue skies maybe? Or has that just disappeared from...
No, it hasn't disappeared. It's actually a good observation. It's in the blue skies, if you like, are people actually happy in their job? They like their organisation, but they're also thinking about a future in a way that they hadn't previously thought about. In other words, the 2 years of lockdowns have accelerated people's views of a different lifestyle in the future. They're not unhappy with what they do, they're not unhappy with their job, but they're now thinking about, what that future might look like outside of the context of work. So that brain picture might have missed that. Yeah,
it
wasn't as explicit.
Yeah, it wasn't meant as a criticism.
No, it's a good observation.
But it also struck me that that's maybe, forget the percentages, that there is a real shift. Everything you're saying is that there's a real shift in terms of people being content, stable and satisfied to a real, a huge group who are now always looking for the next thing, which is a real challenge. And shows in the stats about having 25 different employers in your career.
It's a really, I don't know about everybody else, but you get a group of individuals, the 30% that are actively disengaged, we spend 90% of our time trying to appease, motivate, engage with, change, to capture an audience that, to be honest, is not going to be captured because they don't want to be. So you tend to lose on those blue skies because that's probably where you're going to get your best output from, your best engagement, including those that are present. But that presentism, they're there doing it, but they're just doing it.
My question is to Paul. and regarding the brain that you so nobly pointed. Is it possible that you could put an age bracket on each one of those segments? Like I would say that the 30% you're looking at would be your Gen X's and your Gen Y's, because the wording I've received today is that a Gen X or a Gen Y will start their job today. Tomorrow they're looking for their next job. Would I be safe to say that?
I don't have any statistics that would support it. Intuitively, based on my experience, that would be absolutely right.
So in the 54% bracket that you've got of the blue skies, they'd be up around the 30 to 55 age bracket or more.
Probably older than that.
I mean, I've just employed a 69-year-old accountant, right, to work in our business, because we've got two businesses. One's an accounting practice and an aged care business, which I'm the CEO of. And he was reduced to cleaning in a aged care facility because he couldn't get a job elsewhere.
Well, you saw the statistic earlier where you are unemployed and of an age of 55 and above, the average is 80 odd weeks to find meaningful employment. So when I mentioned about a skill shortage, there is, the 16.6 million employed Australians that we will all try and seek input from and try and seduce them out of jobs. There's this other workforce that is lying dormant that potentially could cater for some of the roles that are not being able to be filled. And the aged bracket is an important one. I didn't include this statistic in these, but part of the organisation I work for has a very strong disability employment service. That is also a very significant workforce that is not being utilised anywhere near its efficiencies.
The education systems behind positions affecting the output of workers though?
Insofar as moving forward in 2026 and above, I think it's 60% of all roles will require some form of graduate diploma degree to be able to perform. So they will play a very big role. But the other big role that educators are currently playing is the reskilling of people into other roles that they otherwise aren't qualified to do. So a very big role, which is one of the reasons why I think the federal government is talking about free courses so that people can be re-engaged and skilled. So that educators will play a pretty significant role.
Paul, is there any more recent evidence that suggests the shine, if that's the right word, model is fading somewhat, and that employees are starting to realise that by being at home for say softer aspects of being in an office, particularly, if I might say so, in a firm like ours, where there's some benefits that would be said about being able to pop in and knock on and all that sort of thing. Is there any more recent evidence around that?
That's a really good observation. I made a point earlier that in 5% of the workforce did work from home, and now we're going to land on 15 and 20%. The vast majority of workers are saying, I miss meeting people and talking to colleagues. I miss that aspect. But I don't want to get in a car and travel for an hour and go to an office and then spend the rest of the next 5 hours talking at the water cooler, catching up on gossip and engaging. So there is a sense now that that hybrid model will be, you can continue to work from home, but you're coming into the office 2 days a week because you're doing this. It is about engaging with other people as opposed to doing things. So workforces will be doing this more. There's a reason for you to come in, to listen to someone speak or to catch up with employers or your colleagues as opposed to coming to work and working.
Thank you, Paul. Thank you, everyone, for coming. And just a reminder that we've got our objecting to land tax notices function on the 28th of July, our next business breakfast, so please all come along. Feel free to come. Thanks very much for coming.